Good evening, everybody. I welcome you all to our free and introductory session on professional responsibility and legal ethics. My name is Hannah. I'm a barrister and solicitor in the province of Ontario, and nothing I discuss today constitutes legal advice. It does not give rise to any solicitor-client or barrister-client relation between us, and that includes fiduciary, contractual, professional, and agency relation. Whatever I will discuss over the course of next few hours is only meant for educational purposes. In addition, you're strictly prohibited from recording this session, and in the event you do so, not only will you be breaching my privacy, but you shall be breaching the privacy of every single candidate attending today's session. Please note the materials that I have prepared exclusively belong to me. They can neither be printed nor be downloaded and must not be accessed in any unauthorized fashion. Furthermore, I request you all not to ask any questions stemming from the examination content as defined by the Law Society of Ontario in your respective lawyer licensing agreements. With that said, I will start sharing my screen and we are going to begin with the very first topic today, which is what it means to be a lawyer in terms of the regulation of the profession. So when we talk about being a lawyer, we are essentially talking about a profession that regulates itself, right? And our regulator is known, as you all know, is known as the Law Society of Ontario. The Law Society of Ontario has a duty to protect the public interest, number one, to maintain and advance the cause of justice and the rule of law. Third, to facilitate justice for people of Ontario and to act in a timely and efficient manner. What this essentially means is that these are the four main duties of the Law Society of Ontario. This is in fact the mandate of Law Society of Ontario. But when we talk about being a lawyer, essentially we are looking at two aspects. And I often say this that a good lawyer is not just someone who understands or who's competent technically, but it also encompasses character requirements. And that's why, when you're preparing your application or you're filing for your application before the Law Society of Ontario, like you're doing your registration. I don't know, but right now, back in the day when I had registered my application approximately half a decade ago in 2020, interestingly it was in December 2020, we actually had to mention if there are any proceedings against us in any courts or have we been convicted, so on and so forth, because it is important to have, um, it's important to not just be technically sound, but also when it came to having a character, they meant that you should possess a good character, which means your conduct needs to be above reproach at all times. So if you look at what it truly means to be a lawyer, we are essentially looking at two aspects: competence and character requirements, right? Now, what are the four main areas of the LSO? Number one, convocation and management. The last, I think, convocation took place on November 27th, which is where your legal fee, like your licensee's fee, was increased. Education, licensing, and professional development, professional regulation, resources and support for lawyers, paralegals, and public. So these are the four main areas of the LSO. We are looking at convocation and management, education, licensing, and professional development. So your licensing exams fall under this category. Professional regulation. This actually ensures that whenever a law society holds regular audits of sole practitioners and firms, they basically want to see if you have been able to fully comply with the bylaws, etc., etc. And finally, resources and support for lawyers, paralegals, and general public. It is here when, if you call the Law Society, in case you're stuck, you have your practice management helpline that falls under this. Your apart from practice management, I think your coach and advisor network also falls under this. So basically, we are looking at the resources that or member assistance program for mental health support, or DHC, which is discrimination, and harassment council. Essentially, we are talking about all the supports that we need as lawyers to do our job. That is sort of encapsulated under this area of the LSO. Now, when we talk about professional regulation, we are talking about convocation. This usually takes place once a month, where the benchers of the LSO, the directors who govern the LSO, they meet. And LSO is essentially governed by a body of directors. These directors are elected every 4 years. They are known as benchers. So members from legal community, they run for the position of benchers, and based on the number of votes they secure, they are elected to the position of the bencher. Benchers make policy decisions and deal with other members related to the governance of Ontario's paralegals and lawyers. They participate in LSO committee meetings and they sit on various panels. The staff and the day-to-day operations of the LSO are governed by the CEO, who's the chief executive officer of the LSO. So you can say like the top guy who's responsible for the staff, the day-to-day functions, how the LSO works on an everyday basis, that is handled by the CEO. The head of the LSO is the treasurer. So the treasurer is somebody who is selected amongst the benchers as the head of the LSO, and they're responsible for taking all the major decisions. When we look at the licensing, education, licensing, and professional development, so your education and practice supports that are available to lawyers and paralegals, your licensing requirements, like I said, your continuing professional requirements, they all fall under this. If there is an issue with a lawyer's competence, it's taken care of by education, licensing, and professional development. So also your practice support, when we look at the Great Library, which is in Osgood Hall LSO's office, practice management helpline, coach and advisor network, they all fall in this category. When we talk about professional regulation, it is here that we are looking at a response to various regulatory complaints, allegations, or let's say if your client is unhappy with you, the department or the area of LSO that will be responsible for investigating the complaint, for prosecuting in case they have found that there are some issues with the conduct of the lawyer, or there's an issue of misconduct, misappropriation of trust funds, essentially anything and everything that needs to be regulated as far as the profession is concerned, that is taken care of by professional regulation. So your trustee services, any wills that are prepared by lawyers, unclaimed trust fund and compensation fund. This is essentially for clients that have suffered as a result of the deceit and dishonesty and fraudulent actions of the lawyers. They are taken care of through this fund, which falls under the professional regulation area of the LSO. Now, when we talk about support to licensees and public, we are essentially looking at a client service intake. Think of it as a call center that takes all your complaints, right? All the inquiries that you may have, administration, any communication that needs to be handled by external relations and communications divisions, they're all handled by the support to licensees and the public. What are the rules of professional conduct? They're essentially a code of ethical behavior of lawyers, breach of which leads to complaints, investigations, and enforcement processes. Are the rules a complete code of behavior? The rules do not encompass every situation. So that is something that we need to know. And this is why I think it is imperative that we understand how these rules work. In an ideal world, we would want these rules to be our GPS, right? Taking us through every possible situation. But that's not really possible because a set of rules, no matter how comprehensive they cannot anticipate every situation that might occur. So I was reading this somewhere, and based on that, I thought that the rules are not, they don't perform the function of a GPS, but of a lighthouse, where they tell you where to go. They tell you the path, but they will not direct you. So they will indicate to you how you need to be in a particular situation. But that those rules need to be, so to speak, used with a lot of common sense and understanding of the situation. Like that's why for some areas that are conventionally difficult for candidates to understand, like conflict or confidentiality. Where does privilege end and confidentiality, where does privilege end and confidentiality begins? Or for that matter, is this serious enough for me to withdraw from a particular client? The rules will tell you what needs to be done, but the application of rules requires a lot of common sense. And that's where I think it's important to do the number of practice questions that we do so that you're able to understand how we are able to use these rules. Like yesterday, when I was in my solicitor's class, Shizom asked a very good question. He said, "Oh, you've told us so much about joint retainer. Tell us one rule that we can apply." And I said, no, because from the same rule, or from the information that I have given, there are at least 6 to 7 rules that come into play. Now, which rule you will apply depends entirely on the fact pattern that you have before you. And therefore, to say, okay, give me, explain it in one sentence, it's, if I do that, actually, I'm doing a greater disservice. And chances are that you won't get right answers. So anybody who tells you, oh, I have a cheat sheet for the rules, or I can tell you exactly which rule to apply in what situation, don't believe them. There is a reason why failure rate is so high, especially in solicitors, is because we are not able to merge the rule with the practice area. And for those of you who are our regular candidates, please understand that if you study the practice area on your own, on a standalone basis, it's not going to help. You have to merge the nuances of the practice area with the rules and use a lot of common sense. And that's exactly what LSO is also trying to say. What they are trying to say is apply rules cannot anticipate every single situation. So please use a lot of common sense when you apply them. And there is somebody by the name of MN who has just entered. So can you please identify yourself? And I'll stop the recording till the time I have heard from this person. Right? So the rules do not encompass every situation and should be used with some should be used with common sense and consistent with public interest and integrity. Now, that brings us to the question, how are you going to resolve an ethical issue? You see, the most important thing, which I personally believe, considering I work with a lot of new lawyers and legal community in general, is they are not able to identify the issue involved. What is the issue in a given fact pattern? Where is the fact pattern taking me? What is the legal issue involved? So, the first thing when you want to resolve an ethical issue is to identify the issue. Once you are clear, once we have a problem statement, then it's easy to apply the relevant rule, use the relevant resources, conduct a cost benefit analysis, seek um, guidance, and finally document the decision making process. So, this is the process that we follow. Now, practice, when we talk about professional development, the first thing is practice management helpline. Practice management helpline or practice management questions by lawyers and paralegals, they are handled by practice management helpline. Questions regarding opening a practice, closing a practice, even succession, when you purchase somebody else's practice, lawyer client relationships, managing a file, they all fall under this category. The next is coach and advisor network. This essentially, like I said, provides the support a lawyer needs when they are actually practicing. So let's say if you get stuck and you don't know how to take a particular case forward, this can sometimes happen when you have taken on a file and suddenly you encounter a problem which is difficult, which requires a bit of strategy, or you need experienced eyes to go over the issue. That is when you actually use coach and advisor network. I can tell you it's very, very helpful. Um, Especially, when you end up looking at a problem which is interdisciplinary. And by that I mean it is combining a couple of practice areas of law, and the file had not actually begun when you took on the file. It was not that complicated, but over a period of time, when it increased in difficulty level, it increased in um, complexity, then the best thing to do is to call up coach and advisor network. They will connect you to someone who has who's had similar who's had like a substantial experience in a similar practice area, and you can ask them for their wisdom on a particular legal issue. They support the implementation of best practices, and advisors assist with the substantive and procedural law inquiries on client files. Practice audit departments, well, like I said, your practice can be audited at any point in time to see if you are running a clean ship, if you are fully adhering to the rules of professional conduct. All that falls under practice management audits department. Now, how do you discipline a lawyer, so to speak? You see, first of all, it's not that easy, because the first thing that needs to happen is that the client service center needs to accept the problem, like needs to accept a complaint. From here, it goes to the intake and resolution department, which in fact looks at resolving the issue at the preliminary stage. Think of it as an initial summary advice that you get, or it tries to resolve the issue at a very, very informal level. Um, if your client is not happy just because you did not answer their call and they call up LSO. So it is the intake and resolution department that will try and pacify and say, next time, please be more prompt when it comes to answering their phone calls. So at this level, you are looking at an informal resolution of complaint. From here, the matter proceeds to investigation services. Now, when you look at investigation services, it is crucial to understand that their job is to investigate, like wear the hat of an investigator and see what's the problem, what truly transpired. So, you might have to submit any evidence that you have in your support. You might have to, you might be called a couple of times to give more uh, clarity on what exactly took place. So here they're trying to unearth and understand what occurred. Now, from the investigation services, the matter can either be closed, saying that, listen, the lawyer was not at fault, or it can proceed to litigation department, or it will go to proceedings authorization committee. Now, it is here that the matter will go to a hearing panel. The Law Society, also known as the Law Society Tribunal, actually has two levels. One is the hearing panel, and the other is the appeal panel. So, a hearing panel is where the hearing takes place at The very first stage. Now, if you're not happy with the decision of the hearing panel, you appeal against that decision and you go to the appeal panel, right? So somebody actually asked me in one of the classes, Hannah, what is Law Society of Ontario's tribunal? And I said the tribunal essentially consists of two stages, hearing panel and appeal panel. So the matter will first go to hearing panel if you're not happy with the decision, or if the client is not happy with the decision, they're going to go ahead and appeal against that decision, asking for a reconsideration or whatever else, and they'll go to the appeal panel. Now, if you're not happy with what happens in the appeal panel, then the last resort that you have is a judicial review that takes place before the divisional court, right? For those of you who are in civil litigation with me, remember we had done this in our very first session, jurisdiction.
Yeah,
Raghav, Tabassum, do we remember that?
yeah,
Yes. So once, if you're not happy with the decision I had mentioned of board, commission, agency, tribunal, you go to divisional court, and it is here that you ask for judicial review. So, and once, well, let's say if the lawyer has been found guilty, then there can be suspensions. There can be disciplinary reasons. If the licensee acts contrary to the LSO's rules, legislations, bylaws, the LSO may discipline with an oral or written reprimand, impose a fine, place the lawyer under temporary or permanent restriction on individual's license. Suspension of their licenses can either be for a bit or forever. Relinquishment of license. It is here that the lawyer themselves relinquish their license. They can revoke an individual's license. This actually is an extraordinary remedy that takes place when there is a serious misappropriation of trust account. Like if you've been uh, withdrawing money from your trust account and you have basically been stealing your client's money, it it can have severe consequences. Now, when it comes to automatic reasons, when we talk about automatic dismissal or automatic suspension, we are essentially looking at a procedural misstep, which means you forgot to do something, right? So at this stage, there is no hearing. So if when we talk about suspension, there is a disciplinary reason, which is far more serious, and then there you have administrative reasons, essentially meaning that you were supposed to do something and you did not do, like you did not pay your annual fee to the LSO, which they have increased, by the way. It's become 2080 plus HST. So essentially looking at $2,300 per annum. Law Pro insurance premiums, levies, etc. This, I think their top package is 3,200. And if you want an added real estate insurance, then it's 3,300. So essentially, you're paying 33 plus 23, you can calculate $5,600 per annum only in your fee. Complete and report CPD hours. You have 12 CPD hours. We're going to talk about how they distribute it. File annual reports. This is so important. You have to file your annual report before 31st March, no matter what. Report in the annual report filing in each mixed trust account, including interest held at the time of the licensee's reporting year. So your annual report is essentially a very lengthy document, where you actually have to report how much money you held in your trust account in a given year. Did you earn any interest on that? If you earned an interest on that money, did you send that to Law Foundation of Ontario? Um, what exactly did you work on? Were you, let's say, an estate trustee on some of the files? How many wills you drafted? So essentially, they want you to calculate and, of course, tabulate because it's submitted in form of a table about all the activities that had or that required you, or that essentially had a monetary value attached to it. Like, for instance, if you were acting as an estate trustee, there is a monetary value attached to it. If if you're somebody who does real estate transactions, every third day you'll have some closing or the other. So essentially, all the monies that you've dealt with throughout the year needs to be mentioned over there. Yes, Raghav?
Hi, I'm sorry, I have a question.
Yeah.
So when there's if you scroll a little above in the
It-
intake and resolution department, when there's an informal hearing that takes place when the LSO
There's
is
no
trying to
hearing
resolve, yeah, when they're trying to
in
resolve
informal
within
hearing. Yeah.
themselves. So are there any repercussions attached to it for the lawyer? Like, does the lawyer have to go through any like, you know?
So it's intake and resolution department. It's here where you'd suddenly realize that the complaint technically has no merit because they do not have the ability to investigate. They will try to
Okay.
see if something can be resolved informally without, when I mean resolved informally, it means without any repercussions to the lawyer, because essentially here you have somebody who is an unhappy client, or there is some sort of a misunderstanding, or there's some sort of a communication gap that has occurred, which does
Okay.
not merit any kind of discipline. It's only when it progresses to the investigation services that okay, now there might be an issue. But even even when, let's say, the investigation services were to investigate, a possible outcome can be closure of matter completely because nothing was found. Perhaps when the client said that the lawyer did not attend 100 calls and the investigation services found that it was in fact 3 calls on a Sunday, when the lawyer had categorically mentioned that they do not work on Sundays. Do you see what I'm trying to say? So they'd
Yeah.
say, show us your call records. And when you show the call records, you'd be like, oh, so you were calling this person on Sunday morning at 8 o'clock. And let's say this person has kept a vacation responder, categorically stating, please do not call me on a Sunday. And if it's an urgent matter, go to 911. So now there is no merit. First of all, they're not 100 calls missed. There were perhaps 3 calls missed over a period of 1 year. And those calls were made on Sunday morning at 8 o'clock. This lawyer could have been in church doing their service at that point in time. And at the time when they entered into lawyer-client relationship, they set the expectations correct. Like, there was an absolute, uh, the lawyer actually set the expectations in terms of communication and turnaround, that if you call me on a Sunday, I'm not going to answer your call. Like a lot of people, on Fridays, they don't answer calls because, they're following their religious day or something. So now if the client is unhappy, too bad. The investigation services are going to close the matter. But yes, if there is an active theft, or if there is misappropriation of funds, or the lawyer has acted in an uncivil manner, or behaved in a manner with their clients that breached Ontario Human Rights Code, and we're going to talk about it, then there can be repercussions. At intake and resolution department, there are none, because at this is the stage where they're trying to just pacify the client and trying to resolve the issue. Does that answer your question, Raghav?
Yes. Thank you.
Good. Any other questions, anybody? Guys, just jump. Okay, there's somebody by the name of iPhone who has again entered. I'm sorry. iPhone, can you please? Again, iPhone, can you please identify yourself? I'm going to ask this for one last time. Otherwise, I'm actually going to remove the person from the class. Going back. Yeah. So administration suspensions, they're, automatically lifted. If you're not so the minute you fulfill the compliance, it's automatically lifted. So, okay. If they're not reinstated in 12 months, like if you do not fulfill that requirement in 12 months, which means you've not paid your Law Society fee in 12 months after being administratively dismissed, or you did not complete your CPD hours, plenty of lawyers forget, then in that case, your license may be revoked. right? And then you have to apply for the license again and pay the additional fee. Suspended lawyers, well, you're prohibited from practicing law, prohibited from providing legal services, prevented from representing and holding themselves yourself out as a lawyer. You've got to disclose your status to your clients, prospective clients, former clients, engage other lawyers to complete even simple tasks like preparing a reporting letter. And you have to deal with the client's money in accordance with bylaw 7.1 and 9. I often say this with PR, do not forget to read the bylaw. If you have those, if bylaws are given in your syllabus, they are given for a reason. Please go over the bylaws. I will go over them as and when necessary. In fact, I do refer to bylaw 8, bylaw 7, but it is something that needs to be done. You cannot overlook the bylaws. Now, let's talk about what does it mean to be a professional. A lawyer is required to be professional at all times. So, your standards of legal profession are given in the rules of professional conduct. Under the rules, lawyers must practice law with integrity. So, you'd see all the values that you're supposed to uphold in your everyday practice. I've given over here. Practice law with integrity, be civil and courteous to tribunal support staff, paralegal, clients, opposing counsel, and members of good faith, members of public. You have no idea how important duty of civility is. In fact, these days, LSO and other law associations are exclusively holding seminars on the importance of civility in legal profession because you don't really know with the kind of environment we are in, we don't really know what the other person is going through. So instead of being aggressive, you have to make space. And if that means explaining to your client the importance of taking a reasonable position, please do it. Act in good faith, take part in community activities, refrain from tarnishing the reputation of profession. Respect for human rights of all individuals, irrespective of where they come from. You must believe and uphold through your conduct equality, diversity, and inclusion. And you have to be respectful towards your employees, your support staff, your law clerks, your legal assistants, your paralegals, everybody, and create an equitable workforce. So when we are talking about rules of professional conduct, these feature everywhere, like and sometimes fellow lawyers can complain saying that I was treated badly by the opposing counsel, or your legal assistant can go to the LSO and say I was screamed at by my superior, or your employee can go to LSO and say that, I was not accommodated, because you do have a duty to accommodate to the extent of undue hardship. So you'd find that these value systems, so to speak, are very, very crucial. Now, when we talk about Rule 2.1-1, a lawyer has a duty to carry on the practice of law and discharge all responsibilities to the clients, tribunals, public, and other members of the profession honorably and with integrity. You need to ask yourself, can you afford to be irresponsible? What is truly considered unethical behavior? What is lack of integrity in profession? Does your conduct inspire confidence? So whenever you are in dilemma, you have to ask yourself these things. You've got to remember the keywords here. This is like an examination tip. Remember the keywords here: ethics, integrity, responsibility, workplace conduct. Very, very important. A lawyer has a duty to uphold the standards and reputation of legal profession and to assist in the advancement of its goals, organizations, and institutions. And how can you do that? By participating in community activity and legal aid, by providing pro bono services, through sharing knowledge. So essentially, by doing that, you ensure that the integrity of, it remains intact, and not just remains intact. It's in fact, it's furthered by how you are. When it comes to being courteous, like I said, you've got to be civil. You have to act in good faith before the tribunal and with all the persons you have your dealings with. Legal contempt of court and professional obligations outlined here are not identical, and a consistent pattern of rude, provocative, or disruptive conduct by lawyers, even though unpunished as contempt, may constitute professional misconduct. So it is important that we are not talking about contempt of court as in what is contempt of court in legal terms. Professional misconduct is equally important and and even though it might not be punished as contempt, there might be, the Law Society might take action against you for professional misconduct. Lawyers must comply with Ontario Human Rights Code, also known as OHRC. It was enacted in 1962 and prohibits actions that discriminate against people based on a protected ground in a protected social area. So, protected grounds are age, ancestry, color, race, citizenship, ethnic origin, creed, disability, family status, marital status, gender identity, receipt of public assistance, record of offenses, sex, sexual orientation. These are all protected grounds. The other grounds, when you talk about accommodation, are, the other grounds are contracts, employment, goods and services, membership in unions, trades, and professional associations. So you have to be extremely accommodative and you cannot discriminate against people on the basis of the protected grounds that were just shared. So you have to ask yourself, can I open and operate a law office without a ramp? Can a lawyer's office only have bathroom for men? How about having an office where you pay people of color lesser than those who are not? Can you float a job vacancy that says only that people who belong to 2S LGBTQAI plus are not allowed to apply? Can you have a vacancy like that? And you have to comply with rules of professional conduct, RPC, and OHRC, Ontario Human Rights Code. You cannot escape it, right? So at no point in time can you escape all this. Then comes discrimination. Now, it is important that you understand that you are essentially dealing with an extremely diverse, um, you're always dealing with people who come from different walks of life. Okay, so they're extremely diverse. When it comes to communities, you have different communities from different walks of life in Ontario. And as a lawyer, you cannot discriminate against them on any of the grounds that I had initially mentioned. What this essentially means is that you cannot make racist jokes. You cannot crack sexist jokes in front of your clients and colleagues. You cannot ask someone who suffers from physical disability not to apply for a job in your law firm. Now, let's let me ask this question. Let's say you have an anti-nepotism policy in your office, and you know that one of the job applicants applications is from the significant other of your colleague. Can you ask about their marital status in this case? Can I ask whether you are married or not? I know that this person is in a serious relationship with a colleague of mine, but I also have an anti-nepotism policy. Can I ask this question? Can I ask about their marital status or their relationship status? Why? Why can't I? I have an anti-nepotism policy. Why can I not? By not directly. Okay, so explain it to me. How are you going to do it indirectly, Aarti? What are you going to do indirectly? Aarti, what are you going to do? Yes, Raghav?
I mean, in a way, you can ask that if you know somebody in the office, like, when you know that she's married to a colleague, you can ask that.
No, I cannot say whether you ask whether you're married or not.
No, but you can ask that, do you know someone in the
Yes,
office?
that is something you can do. Conflict check. Ajay, why will conflict check come here? How did you hear about the job? But that they could have heard about the job through LinkedIn. How does that help me? Because I also have an anti-nepotism policy. Rashmi, she says, are you related or connected to anybody in this office? That's right. But Madhur, how did you hear about this job? How will that help me? They can say I heard it through LinkedIn or Indeed. I want to establish that I cannot hire you because I have an anti-nepotism policy. But I cannot ask them about their marital status because OHRC strictly prohibits me from asking such questions. So again, I will have to ask the same question in an indirect manner. Now, when we talk about harassment, you cannot engage in harassment or sexual harassment of any kind, which includes unwelcomed sexual advances, requests, sexual favors, so on and so forth. When you talk about employment practices at workplace, Rules 3 6.3.1 3 talks about occupational health and safety. What this essentially means is that you are required to comply with OSHA, which is Occupational Health and Safety Act. It is automatically applicable to you. And employers must prepare workplace violence and workplace harassment policies and review those policies as often as necessary, but at least annually. Lawyers who employ six or more workers must have written policies that are posted at a conspicuous place in the workplace, right? OSHA requirements basically say that you have to have a policy which talks about how the office is going to investigate if there is a complaint of workplace harassment, or if there is a complaint of sexual harassment, or if there is a complaint of workplace violence, how will, or tailgating, for example, how will your office deal with it? These issues have become real because at the end of the day, it's the safety and security of your staff that is equally important. So you have to have these policies. And if you employ more than six workers, you must have written policies and they have to be pasted conspicuously in the workplace. Like I can tell you, even though in my firm we are five people, we're not six, but we still have this policy displayed. Now, this basically means that if there is a complaint, it does not matter if it's one time action or a pattern, you have a duty to investigate the complaint. You have to take more information from about the incident and the complaint, include the identifying information about the individuals involved. This will not be disclosed unless necessary for the investigation or for taking corrective action with respect to incident or complaint. How a worker allegedly experienced workplace harassment and the alleged harasser will be informed of the results of the investigation. All of this has to be explained categorically. When we talk about Occupational Health and Safety Act, well, sometimes you might have to conduct a third party investigation to reach at the bottom of things, and therefore this has to be done at your expense. You cannot expect the employee to pay for it, right? Then comes cultural competence. Now, cultural competence simply means whether you are culturally sensitive or not, right? Are you running a place where people are sensitive to other people that come from different socioeconomic and religious background. For example, you should always ask for dietary restrictions and dietary preferences before offering food. Do not insist on consumption of alcohol or meat because it is prohibited in certain religion. You should be able to identify microaggression and cultural homophily. For instance, when you see a person of color and when you clutch your bag, that is an act of microaggression. When you ask a question like, how is your English this good? It's a classic microaggression. You've got to ask accurate pronouns before you address someone. Do not assume that they're going to use a Mr. or a Mrs. Don't do that. Ask them what are their preferred pronouns. Is it he, him, or is it she, her? Is it they, them? How do they want to be addressed? Very, very important. Cultural homophily, this is important because, it's often said that birds of a feather flock together. So, which essentially means that there is this um, bias towards your own people. You have this tendency to lean towards members of your own community or age or ethnicity. As a result of that, there is not much intermingling or intermixing, and therefore cultural homophily as such needs to be discouraged. Bec- and the more diverse your workplace is, the better. Lawyers must run a culturally competent practice that includes giving religious holidays that are not necessarily a part of their own culture. Like, for instance, I don't really need a holiday on 25th December, but I definitely need a holiday on days that I celebrate my festivals. So that is why you basically say that you've got to accommodate. When it comes to diversity and inclusion, they they're two extremely different people. They're extremely different, and people tend to get confused as to how to address questions regarding diversity and inclusion. You've got to understand that diversity, when you talk about diversity, essentially you're talking about numbers, right? When I say I have a diverse workplace, I am talking about numbers. Happy people from different communities work over here. I have people from 15 communities that work in my office. That is a diverse workplace. But is it inclusive? Because inclusion means offering a seat at the table, involving them, including them in the decision-making process that will impact them. So when you talk about diversity and inclusion, it has to be not just about representation, but also about decision making. Diversity ensures representation. Diversity is what, inclusion is how. It's not just about what does your workplace look like. Oh, I have people from 15 countries. How many people from those 15 countries are included when you are taking decisions about them? None. So you have a diverse workplace, sure, but it's definitely not inclusive. Lawyers must implement appropriate policies and practices that foster inclusion. So when you look at an inclusive legal practice, it's not just about your workplace, but also about client service. Like, for instance, if you come to us, it's not that we'll have differential fee structure. At MNC law, it's pretty run a pretty equitable sort of a workplace where we don't say no to client who's it doesn't matter which community are you from, or whether you're from a minority or not. Interactions with other lawyers is not to be motivated by bias. You cannot be rude to a fellow lawyer just because they come from a different community. It's your obligation to promote diversity and inclusion. You've got to ensure that your office space is accessible, right? And partners and employees must be trained in cultural competence, provide accessible documents to the clients. And by that, I mean you must comply with, if you are taking down notes, please add this sentence: with the accessibility for Ontarians with Disabilities Act. This is called AODA. ODA. Your documents need to be ODA compliant. And by the way, if you are not, if they're not, by 1st January 2026, then Law Society can in fact take action against you. They have to be ODA compliant. You've got to check with the clients if they need any accommodation. Don't schedule your meeting when you know that the other person has a religious holiday. You've got to make that exception. You cannot have those meetings arranged when it's their religious holidays, or especially when you have clients with special needs, or they have they are suffering from some physical and mental health condition. You've got to accommodate. Design workplace policies to make space for all lawyers and employees. Serious investigation into complaints of workplace discrimination and harassment. Remove barriers at workplace to avoid unconscious bias and cultural homophily. I think we discussed this. Make accommodations for pregnancy, care of relatives, people from different communities and religious backgrounds. There is something called Discrimination and Harassment Council, DHC. I think I spoke about it earlier in the session, that provides safe and confidential space for individuals who have experienced discrimination or harassment in the profession. It is a free of cost service, essentially. Now, let's talk about one of the most essential aspects: identifying your clients, right? What is your primary duty as a lawyer? Client service, right? And what does quality of service include? It includes being competent, confidentiality, avoiding conflict of interest, continued representation unless there is a good cause to withdraw. So when we talk about quality of service, these four need to be stressed on, where it means that you've got to be competent, you've got to maintain confidentiality, you must check for conflict, not just at the beginning of the retainer, but throughout the course of the retainer. And do not go cold turkey on your client. Do not withdraw without a good cause. And what is it? We are going to discuss that. There are separate withdrawal rules. So each of them, we are going to dive deep into each of these. Now, Rule 1.1 talks about who is a client. Excuse me. Anyone who consults a lawyer or on whose behalf the lawyer renders or agrees to render legal services, or having consulted a lawyer, reasonably concludes that the lawyer has agreed to render legal services on their behalf, is a client. So, if you have consulted a lawyer, right, or you are of the opinion that you are going to be represented by this person, essentially a lawyer client relationship has in fact come into existence. And this includes a client of a law firm in which the lawyer is a partner or an associate, whether or not the lawyer handles the client's work. Who is a prospective client? Anyone who invokes lawyer's professional knowledge without signing the retainer, raised a bill, prepared an account for fee and disbursement, or even agreed to represent a person. That is a prospective client. So anyone who calls you and says, "Can you help me?" that person is a prospective client. A retainer is not a mandatory requirement with a prospective client. So when we talk about an initial consultation, an initial paid consultation, whether or not it progresses to a full-blown retainer, that's a separate issue. But initial consultation, which is a paid consultation in some cases, that person is your prospective client, right? For example, a gentleman walks up to you at a party and starts talking to you about the strained relations with their spouse and asks, what, in your opinion, is the best way out of this? Do you think a lawyer client relationship has come into existence? Do you think a lawyer
No,
client relationship? No,
no,
it
that's
hasn't.
yeah.
What about others? Do you think a lawyer client? Okay, there's one need to stop. Yes, Shizom, you said a lawyer client relationship has not come into existence. Shizom thinks that there is no lawyer client relationship here. What about others? Do you think this person is a client if they come and disclose some confidential information to you and ask you for your opinion?
It's a prospective client.
Okay. Uche says there is a lawyer client relationship. Amal says no. Rashmi says yes. Timbian says no. Jaspreet says yes. Until a valid contract comes into existence. But Amal, I just said that you don't need a valid contract. Yes, confidential information is revealed. Uh, yeah, no, Hiral. If the advice is given by the lawyer, yes. Parul says yes. Let's go back to the definition of client. And that's why I say rules are so important. Rules describe a client as a person who consults a lawyer and on whose behalf the lawyer renders or agrees to render legal services. And having consulted with a lawyer, reasonably concludes that the lawyer has agreed. Now, here, can you see whether this person has, in fact, can you can you see if this person agreed to give them legal consultation? So the answer to that is no. Lawyer-client relationship has not come into existence. Shizom is right, but the lawyer still has a duty to protect this person's confidential information because this person is a prospective client. Even if a retainer agreement has not been formally inked, the lawyer is required to protect the prospective client's confidential information. This duty arises when the prospective client first contacts the lawyer and continues indefinitely. Each time a protective client is retained, every lawyer, member of the staff of the firm should be notified of the client and and in and of the related and instructing parties in the matter. There has to be proper file arrangement, conflict check mechanism, so on and so forth. How would you assess if a lawyer client relationship comes into existence? Now, imagine if this person would have given him their opinion on how to deal with this person's strained relations with their spouse. Would have said that, you know what, I think in this given scenario, you are a common law spouse, so there is no equalization claim that your spouse can make, and there is no matrimonial concept of matrimonial home here, and your spouse can only have four remedies of unjust enrichment, I don't know, constructive trust, resulting trust, so on and so forth. So now, even though there is no formal relationship that has come into existence, this person can reasonably believe that I'm going to be represented by this lawyer. And the reason is this lawyer has already explained what needs to be done. So, therefore, it is important to look at the factual matrix before you come to the conclusion whether lawyer-client relationship in fact exists or not. For instance, Sam is a real estate lawyer who's attending a Christmas party organized by his childhood friend Pam. Pam's wife, Lam, is engaged in the business of selling jewelry. She's searching for a store to open her jewelry shop. Sam walks, Lam walks up to Sam and discusses her situation with him. Sam tells Lam that she will have to enter into a commercial lease with a 1 year, for 1 year with an option of extending the lease for a period of 2 years. Do you think now that Lam can reasonably conclude that lawyer-client relationship has in fact come into existence? Yes. Yes, it will be, Amal. I hope everything is okay, and let me know if I can support you in any manner. Please take care. Good night. Thus, the standard here is whether it is reasonable for the person to conclude that the lawyer is in fact representing them or not. So, is it a reasonable assumption? The lawyer should be alert to situations where a person may mistakenly believe that they are being represented, and therefore the lawyer should make it clear. So the best way to do that is after your consultation, if the other person has not retained you, then, or you think that you cannot take on the file, send them a non-engagement letter to make it very clear that no lawyer-client relationship has in fact come into existence. What should a lawyer do when they are retained? Confirm in writing whether they will act for the prospective client or not. Inform third parties who will attend meetings with a client that they do not represent them. Avoid discussing legal matters outside the firm or any working relationships. Now, this brings me to the concept of joint retainer, which, by the way, we were discussing yesterday in our solicitors class, weren't we? What were we discussing about joint retainers yesterday? Does anyone remember? I mean, come on. Shazom, you were there in the class. Ajay, you were there. Rashmi, you were there. Isyoma. What had we discussed about joint retainers? Tabassum was there, I believe. Aisha certainly was there. Isyoma was there. What had we discussed? Parul was there. Madhur was there. What did we discuss regarding joint retainers? What are the rules? Shazom, you had asked me a question. I had given you the entire all the steps. What were those steps?
The question, what I asked stemmed from the question, sorry, the hypothetical scenario you created on joint retainership.
Yeah,
You
but
actually,
I answered your question, right? I gave you steps. What were those steps? Do you remember that?
yes, one of the steps you gave, if there's conflict, withdrawal, independent advice and representation, right?
That's
Uh,
right. That's right. That's absolutely right. We had discussed that when there is a situation of joint retainer, right, which essentially means you're being retained by two people. This is very common in real estate because you end up representing the client and you're also being retained by the bank. So that's a classic case of joint retainership, which, it's a joint retainer that you enter into with your client because you are representing the client and the bank. Similarly, if you're drafting an agreement, like a contract, then chances are that both the parties to the contract are going to hire you, and you might end up representing both of them in a joint retainer and enter into a joint retainer with them. So it basically means where you are acting for more than one client. Now, when that happens, the first thing you have to let them know is that, listen, I'm acting for both of you. Second, no information that I'm going to receive from one will be treated as confidential. This is the joint retainers also occur, I forgot, when you're drafting wills, especially for spouses. And if it's a mutual will, it's 100% joint retainer, right? Um, since we have like a prolific wills and estates practices as well, I can tell you that when clients come, and especially spouses, they want mutual wills and cross wills, and they retain you together. So no information that we receive from one spouse is confidential, kept confidential from the other spouse, which essentially means that there's a free flow of information. If conflict develops that cannot be resolved at a later stage, the lawyer cannot continue to act for both or all of them and may have to withdraw completely. So what this essentially means is that uh, when you are signing on a joint retainer, you have to be very clear about what kind of responsibility you are going to shoulder. Also, the rule does not say that it is mandatory for the lawyer to send them for independent legal advice, but in certain situations, independent legal advice is required. You should send them, especially when you see one client being less sophisticated or more vulnerable than the other. This can happen, especially in case of domestic contracts that you are trying to draft between the spouses, and you find one spouse to be particularly vulnerable, less sophisticated, not very educated. English is not their first language. Perhaps they're an immigrant. Perhaps they're suffering from some sort of disability. So you know that the domestic contract needs to be such that it's fair. And therefore, it is prudent to then send one of the spouse that is who's vulnerable and less sophisticated for independent legal advice. A lawyer who receives instructions from spouses or partners to prepare more than one wills, like I said, this is a classic case of joint retainer. The lawyer should advise the spouses and the partners that if subsequently one of them were to communicate or give them completely new instructions or change or revoke the will, the new instructions would be treated as a new retainer. It will not constitute a part of the old retainer. The new instructions will not be shared with the other spouse, and the lawyer will then have to completely withdraw, because at the end of the day, new um, instructions have come in. So what this means is the lawyer has a duty to decline the new retainer unless the previous spouse agrees, or they have divorced, or their conjugal relationship has come to an end, so on and so forth. If a lawyer has a continuing relationship with a client, this can happen, let's say, when one of your friends approaches you for legal advice and you have a continuing relationship with them, and they say, listen, we are purchasing a condo and we need you to close the condo for both of us. Now, in this case, you need to advise the spouse, your friend's spouse, that listen, I've had a long-standing relationship with this person. So I would recommend that you obtain an independent legal advice about the joint retainer so that it appears to be up and up. Okay. Uh, when a lawyer has advised the client and the parties are content that the lawyer, or they consent that the lawyer acts for both of them, the lawyer must obtain their consent in writing. And this has to be a separate communication to each party, categorically asking them for their consent. And the parties need to give their consent in writing that they are okay with this person or this lawyer representing both of them together. However, what happens if there is a contentious issue that arises after the lawyer has been retained? Now, the first thing that the lawyer would do is to not advise them on contentious issues. And you can refer the clients to other lawyers, or tell the clients to settle the contentious issues by directly negotiating, in which the lawyer will not participate. The lawyer will not provide any legal advice. Tell them that you sort this out on your own. And if the contentious issue is not resolved, please withdraw from joint representation. This rule does not prevent the lawyer from being an arbitrator or settling or attempting to arbitrate or settle a dispute between two or more clients or former clients who are not under any legal disability and who wish to submit the dispute to the lawyer. Now, this might typically happen, let's say, if there are two existing clients and now they are in dispute, then this particular lawyer can arbitrate. But they're not saying that the lawyer will start settling the dispute if you are on a joint retainer. Candidates tend to get confused. They say that, this commentary one is diametrically opposite to the rule. No, it's not. And I'll tell you why it's not. No, Vaibhav. What is the thumb rule? Thumb rule is when you have retained two people on a joint retainer and an issue develops, ask them to sort it out on their own. And, if it cannot be resolved, please withdraw. The commentary is saying that let's say you have two separate clients on two separate retainers and a dispute has developed amongst them. In that case, you can arbitrate or settle the dispute. This commentary is not referring to clients that are on joint representation. This commentary perhaps is actually referring to, let's say, somebody who's a homeowner for whom you closed their property and a contractor who's also your client. And both of them now are fighting with each other. So now in this case, it is important that if they come to you, then this rule does not prevent you from settling or arbitrating the dispute. Does that answer your question, Vaibhav? They are not saying you can represent. Correct. Yes, Rashmi. Look at the question. This rule, which rule? Joint retainer rule, does not prevent a lawyer. This rule, which rule? Joint retainer rule, does not prevent a lawyer from arbitrating or settling or attempting to arbitrate or settle a dispute between two or more clients or two or more former clients if they are not under any legal disability. People tend to think that this rule is an extension or this commentary is an extension of that rule. And I keep saying, no, it is not. Because the opening sentence of this commentary is that this rule, joint retainership rule, does this make sense to everybody? Only Rashmi says it does makes sense to her. And Aisha. What about the rest?
Please, could you take it back again? Could you just repeat it for once, please?
Okay. Raghav, can you unmute? I will ask you two questions.
Yes.
Tell me something. If you sign me on as a client and I come to you for a real estate purchase,
Yeah.
and so am I your client now?
Yeah.
Rashmi comes to you, and she is a mortgage specialist, but she comes to you for a very different matter. She comes to you because she's closing a commercial deal. Is Rashmi your client now?
Yeah. Related to you, the
No, no.
deal?
We are two
No.
separate
Okay.
retainers, right? We are two
Okay.
separate clients, correct?
Yeah.
Clear?
Yeah.
Neither of us are under any legal disability, correct?
Yeah.
Now, if there is a dispute between the two of us, can you help us arbitrate and settle that dispute?
I got it. Yeah, I can.
Yes. But if Rashmi and I were to come together and retain you for the same matter, then it becomes a joint retainer. Now, if there is a dispute between the two of
You
us,
you'll have to resolve it personally before me proceeding with it.
yes. And since I like Rashmi, I would say, Rashmi, whatever you say, I'll agree. See, your job is simple, Rashmi's job is simple.
Got it. Thank you. That was very clear. Thanks.
And yeah, I try to be funny sometimes, but I fail.
This was a good attempt.
Jizome, is it clear to you now?
Yes, but if I may just ask, like, what do you mean by if there is dispute between these two separate clients?
It can happen. We can have dispute regarding anything, no? Jizome.
But
Let's say I am Rashmi's. I purchased a house from. I asked Raghav to help me close a home, but for some reason I end up losing the home, And Rashmi also goes to Raghav and asks him, "Can you close a home for me?" And tomorrow I'm Rashmi's renter. I'm her tenant. Why can't there be a landlord-tenant dispute between Rashmi and myself?
Okay, okay, understanding. Thank you.
I mean, I'm Raghav's client. Rashmi is Raghav's client. Neither of us is we Raghav did not retain us on a joint retainer. We are individual clients. And now I'm renting out Rashmi's property. Then we will discuss law. What do you mean by that, Rashmi? The law discussions are always like deep discussions are there. The constitution, these. Can I tell you, I get exhausted because I talk law for almost 20 hours a day, like with the province, with the firm, with you guys. Like find spaces where I can talk about something else. So if I were your renter, we would talk about pizzas and Bollywood films. That's also true. So if there is a landlord-tenant dispute, why why can't Raghav mediate or help us settle the dispute? And this is what I said, Shizong. If the clients have consented to a joint retainer and an issue contentious between them or some of them arise, the lawyer is not necessarily precluded from advising them on a non-contentious matter. If Rashmi and I were represented by Raghav on a joint retainer and there is a dispute that arises, let's say with regard to the title of the property, Raghav can still advise us on perhaps zoning bylaws because it's a non-contentious issue. Subject to this rule, if a client consents to a joint retainer and also agrees that in case a contentious issue arises, the lawyer may continue to advise one of them. This will happen when there has to be an absolutely informed consent. You cannot take this consent beforehand, and the consent has to be taken when the dispute arises. The lawyer may advise the client about the contentious matter and refer the other person to another lawyer. If the rule does not relieve the lawyer of the obligation when the contentious issue arises to obtain the consent of the client. So it is when the contentious issue arises, then you have to take consent. You cannot take this blanket consent right at the beginning when things are hunky-dory. So, but if a contentious issue develops and you know that your clients are not consenting, please withdraw. That is what the rule categorically says. I don't want to start limited scope retainer right now. I want to start limited scope retainer next Wednesday because this and clients with diminished capacity. This topic will take time. So I don't want to do it today. I want to do it like next Wednesday. Next Wednesday would be December the 10th. And yeah, so I think I'm going to finish this topic on December 10th because it's already 9. I want to do some practice questions. Client identification, verification requirements, being competent. This is what we're going to do next Wednesday. We're going to start with duty of confidentiality. Yep. So I think this is what we're going to do next Wednesday. All right. Now I need volunteers. Who is going to read the question today? I give you the logic behind it, so I need help.
I can
Who's
read
reading
and I don't mind.
questions? What? Who said that? Thank you so much.
Sorry, Madhur here. I can
Oh,
read.
thank you. Thank you so much, Madhur. You always
No
come to my
problem.
rescue. Means a lot, yeah.
No problem at all.
Yes, I'll just put myself on mute and give my throat some rest.
Okay. Samantha, a newly licensed solicitor in Ontario, is eager to develop her legal skills and stay up to date with changes in the law. She's aware of the importance of ongoing professional development but is unsure of how to navigate the resources available to her. Samantha wants to ensure that she serves her clients competently and meets the LSO standards for professional responsibility. Which of the following resources provided by Professional Development and Competence Division would be most appropriate for Samantha to utilize to fulfill her continuing professional development CPD obligations and address any competence concerns that may arise? A. The Practice Management Helpline, which provides advice on law office management and technology. B. The Great Library, which offers access to legal texts and case law but does not include practice resources for professional development. C. The Coach Advisor Network, which helps lawyers by pairing them with mentors who provide guidance on improving their legal practice skills and competence. D. Spot audits and practice reviews focusing on lawyers identifying and correcting competence issues. Yeah, let's see. A complaint has been filed against John, a lawyer for allegedly mishandling client funds. The complaint is within the Law Society's jurisdiction, and it is clear that the issue could be resolved informally. The Law Society's Intake and Resolution Department has reviewed the complaint and determined that informal resolution is appropriate. John is informed that he must respond to the complaint, and failure to do so promptly and completely would result in a disciplinary action. Which of the following best describes the actions that could occur after the Intake and Resolution Department determines informal resolution is appropriate? The complaint will be automatically referred to investigation services for a full investigation, even if the issue could be resolved informally. John will be required to appear before a hearing panel to present his case, as all complaints involving client funds must result in a formal hearing. John may be required to participate in CPD or professional training as part of an informal resolution process. The complaint will be dismissed as informal resolution is only for minor complaints and do not require any corrective actions. Please. Okay. David is a lawyer, has recently been suspended by the Law Society. The suspension was due to his failure to pay the annual fees to the Law Society despite several reminders. This type of suspension is considered to be a disciplinary suspension, which means that David's suspension is a result of misconduct or professional conduct. An admin suspension, which is a suspension for failing to meet admin obligations and can be lifted once David meets the required obligations and pays a reinstatement fees. A permanent suspension, which means David will not be able to practice law again and must apply for reinstatement after 12 months. A disciplinary suspension, which will result in David's license being revoked permanently, and he will need to apply for reinstatement after completing specific tasks imposed by Law Society. B. Admin. Alice, sorry. Alice, a lawyer, is reviewing the intake procedure for her law firm. She notices that the firm has a policy that requires all clients to attend in-person meetings for initial consultations. However, some potential clients with disabilities have expressed difficulty attending due to mobility challenges. Alice is concerned that the policy might unintentionally disadvantage people with certain disabilities. Which of the following types of discrimination does the situation best illustrate, and what is Alice's obligation? Direct discrimination, because the firm's policy explicitly disadvantages individuals with disabilities and Alice must modify the policy to avoid treating them unfairly. Indirect discrimination, because the policy applies equally to all clients but disproportionately impacts individuals with disabilities. Alice is required to accommodate these clients unless doing so would cause undue hardship. Systemic discrimination because the policy reflects broader societal power imbalances, and Alice must address the policy as part of a larger change within her firm. No discrimination because the policy applies equally to all clients and was not intended to disadvantage anyone. B. David, a lawyer at a prominent Ontario law firm, is tasked with representing a corporation, EcoWave Solution Inc., in a legal dispute. During his initial meeting with EcoWave's executive team, David is asked to provide legal advice regarding a potential merger with another company. The executive team consists of multiple individuals, including the CEO, CFO, and general counsel, each of whom has distinct interests in the transaction. David is unsure of the identity of his client in this scenario, and he is dealing with multiple individuals within the corporation. He must ensure that he meets his professional and ethical obligations, including identifying the client, fulfilling his duties to meet the client, and complying with LSO requirements. Which of the following actions must David take to properly identify the client and meet his ethical obligations? David should request a formal retainer agreement from EcoWave Solutions that explicitly names the corporation as his client, specifying that he represents the corporation and not any of the individuals on the executive team, even though the individual executives may provide instructions on behalf of the corporation. David should obtain and verify the identities of CEO, CFO, and General Counsel in accordance with Bylaw 7.1 of the Law Society Act, as they are providing instructions and are likely to be involved in the financial transactions related to the merger. David should send a non engagement letter to the individual members of the executive team, identifying that he will not be representing them personally, but rather the corporation as a whole. He should clarify that he will not take instructions from them individually unless they are specifically authorized to do so on behalf of the EcoWave Solution Inc. David should ensure that the retainer agreement or the engagement letter includes the names of all the individuals on the executive team, as they are the primary contacts for providing instructions and making decisions, thereby clarifying that they will collectively act as the clients in this matter.
It's my bad. I wanted to. This is the A is the right answer. You have to have a proper retainer agreement with the corporation, stating clearly that corporation is my client. None of the individuals are my client. And therefore, also just clarify that I'm going to get instructions from them, but it's the corporation that is my client, not the individual. This is a very important aspect where we are going to discuss in our classes about who is the client when it comes to corporations. Okay. I think I'm going to end the session here. And those of you, most of you, actually all of you, I can see pretty much, I think barring a couple of candidates here and there, all of you are regular candidates. So I'm going to see you for our next PR session on Wednesday. For those of you who are with me for civil litigation, like barristers, we're going to meet on Saturday at 9 a.m. For solicitors, on Sunday at 9 a.m. So you guys take care and have a lovely evening ahead. Bye bye.
Thank you, Al. I
Thank
just
you.
had a question before we go, if I can.
Give me a minute. Let me just
Sure.
see if there are somebody else, like let the candidates leave. Thank you, Madhur.